Hello and welcome back to Study Time Anytime YouTube channel. Today we'll continue from part D, the mobility rights. The first point here is mobility of citizens. Every citizen of Canada has right to enter and remain in and leave Canada. Second, rights to move and gain livelihood. Every citizen of Canada, now note it down that this right is for every citizen, this right is for every citizen of Canada and every person who has the status of permanent resident of Canada. So in this article it has been mentioned every citizen of Canada and every person who has the status of permanent resident of Canada has the right to move to and take up residence in any province. He can move and he can reside in any province. B, to pursue the gaining of livelihood in any province. So he can live in any province and he can work in any province for his livelihood. Third is a limitation. The right specified in subsection 2, so the right mentioned in subsection 2 are subject to A. Any laws or practices of general application in force in province other than those that discriminate among persons primarily on the basis of province of present or previous residence. There may be some law, if any, or practice of general application, not a discriminatory one. Then there is limitation to move or settle or reside or work. B point is any laws providing for reasonable residency requirements as a qualification for receipt of publicly provided social services. So if any law is made for a reasonable requirements to gain residency, for that reason limit can be put up. These 2 points limits the rights mentioned in the subsection 2. Fourth here is affirmative action programs. Subsections 2 and 3 do not preclude any law, program or activity that has as its object the amelioration in a province of conditions of individuals in that province who are socially or economically disadvantaged if the rate of employment in that province is below the rate of employment in Canada. So it has been clearly defined that for the progress and for the betterment of conditions of the individuals, for the betterment of the conditions of the individuals in the province, subsection 2 and 3 do not preclude any law, program or activity that has the objective of betterment and for betterment of those people who are socially or economically disadvantaged, and the condition is if the rate of employment in that province is below the rate of employment in Canada. Then E is legal rights. Seventh, life, liberty and security of person. Everyone has the right to life, liberty and security of the person and the right not to be deprived thereof except in accordance with the principles of fundamental justice. So all the persons have the right to life, liberty and security, but there is exception, that is if there is any if through any principle of fundamental justice the right can be deprived of. Then search or seizure. Everyone has the right to be secure against unreasonable search or seizure. So it is for everyone. Then the detention or imprisonment. Everyone has the right not to be arbitrarily detained or imprisoned. As this is also for everyone, and arbitrarily is important here. Then 10th is arrest or detention. Everyone, again it is everyone, not only citizens but everyone has the right on arrest or detention. What are the rights on arrest and detention? First, to be informed promptly of the reasons thereof. Why a person is arrested, it has to be promptly, immediately informed to the person arrested. Second, to retain and instruct counsel without delay and to be informed of that right, that he has the right to get a counsel to without any delay, and he has that right to appoint a counsel, and this right is to be informed to the person arrested at the earliest without any delay. To have the validity of the detention determined by way of habeas corpus and to be released if detention is not lawful. Whether the detention is correct or not, it is to be determined by the way of habeas corpus. It is a writ where the courts have the power to verify whether the person is in a private detention or illegal detention. They can check whether the person has been detained with the force of law, lawfully by any act or any law, or the detention is illegal, and if it is found illegal, the courts ensure the release of the person detained. Then further are the proceedings in criminal and penal matters. Any person charged with an offense has the right. A person who is charged with an offense, what rights does he has? First is to be informed without unreasonable delay of specific offense. He has to be informed. There should be no delay. Delay can be a reasonable one, but unreasonable delay, without which a delay is allowed only where there are such circumstances that cannot be avoided, but without unreasonable delay of specific offense. Second, to be tried within a reasonable time, that there should be a time-bound situation for trial of the cases. Third, not to be compelled to be witness in proceedings against that person in respect of the offense. So a person cannot be made witness in proceedings against himself. An accused cannot be compelled to become witness against himself. Fourth is to be presumed innocent until proven guilty. So this is a very important point. C and D both are very important here. The person who is an accused but is not proved guilty of an offense, he is to be presumed innocent according to law in a fair and public hearing by an independent and impartial tribunal. Not to be denied reasonable bail without just cause. If there are circumstances where bail is to be given, then the same must be given. Sixth, except in the case of an offense under military law, tried before a military tribunal to the benefit of the trial by jury, where the maximum punishment for the offense is imprisonment for 5 years or a more severe punishment. So, in case of an offense under military law, tried by military tribunal to the benefit of the trial by jury, where maximum punishment for offense is imprisonment for 5 years or more severe punishment. So this is the exception in case of military law. Seventh point here is not to be found guilty on account of any act or omission unless at the time of the act or omission it constituted an offense under Canadian or international law or was criminal according to the general principles of law recognized by the community of the nations. As mentioned in the sixth point, where jury trials were required in the military law cases, where maximum punishment for the offense is imprisonment for 5 years or more severe punishment. In seventh point, they said they provide protection from ex post facto laws, not to be found guilty on account of any act unless at the time of that act or omission it constituted an offense under the Canadian international law or recognized by or accepted by the community of nations under the general principles of law. Eighth is if finally acquitted of offense, not to be tried for it again, and if finally found guilty and punished for the offense, not to be tried or punished for it again. So it is the basic principle of double jeopardy. Once a person is punished for an offense, he cannot be punished again for the same offense, and if has been acquitted, then he cannot be tried again for the same offense. Last is if found guilty of the offense and if the punishment for the offense has been varied between the time of commission and the time of sentencing to the benefit of lesser punishment. So suppose for theft, earlier the punishment was 7 years and later on it was reduced to 3 years. So the benefit of lesser punishment will be given to the person who is found guilty in case there comes the variation in the time of punishment. So this is the end of the video here. We'll continue the series of Constitution. Keep watching the videos and keep liking the videos if you love the effort. Comment in the comment box if you have any question, any suggestion, and do subscribe the channel for regular legal study. Thank you very much for discussion.